Well, it sounds like the beginning of a bad joke. A federal appellate judge appointed by Bush, Obama, and Trump walked into a bar and out walked a peculiar order that was just rendered that takes the a person occupying the special counsel's job, protecting federal workers from being summarily fired, who was summarily fired without cause by Donald Trump. It takes that person, Hampton Dellinger, out of his job after Judge Amy Berman Jackson, in a 30-page, well-reasoned decision, said that he deserves to keep his job because he wasn't being fired for cause, and that Donald Trump firing the head of the one aspect of the federal protection for whistleblowers and federal workers, making him not independent, making him under the greasy thumb of Donald Trump, violated the law, including United States Supreme Court precedent. But this three-judge panel, in an order that literally just came out late tonight, that's the way things are going to happen with this administration. We're going to get a lot of late breaking news. They just ordered that he be blocked from his chair, he be removed from his position as the special counsel, protecting tens of thousands of federal workers from being fired while they go through the niceties of a briefing schedule, finding that the other side of the case, the Trump side of the case, had made out they were entitled to fire Hampton Dellinger. I don't agree, but let me break it down for you here on Legal AF. Here's the order for the United States District Court of Appeals for the District of Columbia. The three judges I referenced at the top: Judge Henderson, who was appointed by Bush; Judge Millett, appointed by Obama; Judge Walker by Trump. And they all got together and they decided collectively in a per curiam decision, meaning it's the opinion of all three of them, that Hampton Dellinger should lose his job, at least temporarily, while briefing goes on about the appeal itself. Here's what it says in the order. Let me read it to you. It is ordered, upon the consideration of the emergency motion for a stay pending appeal, that the stay is granted. It is further ordered that the emergency motion for a stay pending appeal be granted, meaning that Judge Amy Berman Jackson, the judge below, she had issued a summary judgment and a permanent injunction stopping Hampton Dellinger from being fired under a couple of Supreme Court cases, one being called Humphrey's Executor from 1935, which basically says that a federal, the president can't fire a person like Hampton Dellinger without cause, and a more recent case from 2020 called the Celia Law case. But to this three-judge panel, they believe that at the end, that the Trump administration will make out that it's more likely than not that they're going to succeed on the merits of their future appeal, and that the irreparable harm will happen if they're forced to work with Hampton Dellinger one more minute, and the balance of equities tips in their favor. I actually think those three factors certainly are in favor of keeping Hampton Dellinger in his job and maintaining the status quo during the briefing schedule. So they've said that they've granted the stay, blocking the judge's order to stop Hampton Dellinger from being removed. So it's a block of the block, if you will. This order gives effect to the removal of the appellee from his position as special counsel of the U.S. Office of Special Counsel. That's that little-known agency. It's not a prosecutor that protects federal workers in the Merit Protection Service Board Civil Service Reform Scheme that was set up by Congress in 1978. The court goes on to say, without any kind of analysis, but says an opinion or order will be coming later, that the appellants have satisfied the stringent requirements for a stay pending appeal. And they cite to the Nicken versus Holder case from 2009. I read that case. I think it actually runs and cuts the other way. Further ordered, the court on its own motion sets an expedited briefing schedule on the appeal itself. So right now they think that the government is going to win the appeal, but they don't know until there's full briefing. And they set up a briefing schedule that starts with the first brief being filed by the government on March 21. The appellee brief by Hampton Dellinger on 4th of April, and a final brief on the 11th of April. I think there would be a oral argument sometime in April or May, and then a result probably 30 days after that. So Hampton Dellinger is at least out of a job until June or July when it reaches the United States Supreme Court. And we know that Elon Musk and Doge and Donald Trump can do a lot of damage in the meantime in firing federal workers. You know that Donald Trump's going to see this as a green light to continue to hollow out our federal workforce, firing the experts that earn the right to serve America as civil servants. All this BS about corruption in the federal workforce and no-show jobs and people, earning paychecks and taxpayer dollars that don't earn it and deserve it. There's no evidence of that. And if there was, those people would have been fired long ago by the inspectors general, who have all been fired by Donald Trump. That was their job, to ferret out corruption and fraud in the workplace. So how do I read this? And there's another decision that another wait till you hear this. There's going to be another decision on another 3-judge panel, not this 3-judge panel, randomly selected. There may be some overlap, involving a very similar case that just came out yesterday, involving Judge Rudy Contreras, who on the other side of the coin of the Merit Service Protection Board ruled that Donald Trump couldn't remove the head of that organization that was charged with protecting federal workers for the same exact reason and the same exact rationale. And we said on Legal AF that those two cases are going to travel together some way, somehow, by the United States Supreme Court. Now we got to see what that court's going to do on an emergency application there, which I'll probably report on tomorrow. If there's a conflict between the two panels of the two district courts, the two courts of appeal with two different panels of 3 judges, then there's a number of things that can happen. One, if I'm Hampton Dellinger, I asked for a full en banc decision of all 12 or 14 judges of the D.C. Court of Appeals to make the ruling and see if they change their mind in a majority ruling. That's one way to go. They can ask for en banc. They've got to get a majority of the other judges to believe that it's worth having an en banc hearing. Then you have an en banc hearing, and that could happen from this. Or they just take the appeal directly to the United States Supreme Court. I think we're going to get another ruling. If there's a conflict between these two panels, boom, automatic appeal to the United States Supreme Court, when they are really going to have to dig into this 1935 case. Humphrey's executor, does it stand for what it says it stands for, or does it stand for something else? And why did these 3 judges get together and decide that that body of law, which dates back over 90 years, was no longer good law? And it was more likely than not that Donald Trump gets to fire any member of the executive branch, even one he doesn't want to work with for partisan reasons, even if it's not for cause, even though Congress said the opposite. See, the fight's going to be over whether Congress has the power or it infringes on separation of powers to tell the executive branch who they can and can't fire. Have they gone too far? Congress can set up agencies of the executive branch for it, which is sort of weird. But in the checks and balance system, the question is, this unique type of executive agent, executive officer, can they avoid the automatic firing of a president because Congress said so? That's the fight. And we'll continue to follow it all right here on Legal AF. We're going to hit 500,000 subscribers. It's all because of you. We're going to do it before our 6-month birthday. I've been talking it up. Now is the moment. We're so close. It's going to happen in the next 2 or 3 days. Help us be the 500,000th person. Hit the subscribe button. It's for free, but it lets you know when all the content here on Legal AF is being generated, and it'll give you a notification. So until my next hot take, my next Legal AF, the podcast, my next Popok Live, I'm Michael Popok, and I am reporting. In collaboration with the Midas Touch Network, we just launched the Legal AF YouTube channel. Help us build this pro-democracy channel where I'll be curating the top stories at the intersection of law and politics. Go to YouTube now and free subscribe at Legal AF MTN. That's at Legal AF MTN.